There are three different kinds of bankruptcy litigation. Each step is more formal than the next. The least formal is something called a motion, and this is where a lawyer asks the court to do something by preparing or writing some papers, and anybody who has a problem with that writes papers that says, no, that shouldn't happen, and then the judge decides. Then we have a second process which is a bit more formal. It's called a contested matter, and a contested matter is a mid-level, sort of a mid-level dispute resolution process or problem-solving process that involves a little more complexity. It's not just one set of papers. It's not just one court hearing with the judge. It can last for a couple of months. And then for the most complicated issues, we actually have lawsuits that are filed inside bankruptcy cases, and these involve all of the things that lawsuits generally involve. They include a formal complaint, a formal answer, discovery, and other motions inside of that lawsuit, and these can take months, sometimes a year to resolve, and they involve important issues for our clients. Most bankruptcy attorneys handle just bankruptcy cases. They don't do the litigation part, and so they will outsource the litigation to sometimes a firm like us, where we do both. There are firms that only do bankruptcy litigation. They don't do the main bankruptcy case too, but we do both so that you don't have to go to somewhere else if these problems come up in your case.